Good afternoon, everyone. Allison Scoburg here, Consolidated Planning Group. Thank you for taking the time to join us today. Today, I am here with Cynthia Fogelman from the Turtle Wing Foundation, and we're going to hear just a little bit about the Turtle Wing Foundation in just a moment. And I am also here today with Julia Hayes, an attorney with Hayes and Wilson, and we're going to be talking about planning for incapacity. So we're glad that you've joined us today. I always like to start by welcoming you. If this is your first time attending one of our webinars, we're glad you're here. You're in the right place and you're in for a treat for today. For those of you that have joined us in the past, we're certainly glad you're back. From a housekeeping perspective, we are in webinar mode today, and that means that we can't see you or hear you, but we do know you're out there and we're glad you're here with us. Our chat box is open today, and so we invite you to put your questions in the chat box, and we'll get to as many questions as we can during the time that we have together today. So if you're planning, this webinar will go for an hour, and we have a hard start time and hard end time, so you can plan around that. Consolidated Planning Group, for those of you that are joining for the first time, we are a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy, and chartered special needs consultants. Our whole firm is nuanced in planning for special needs. I myself am a parent to more than one child with disabilities who have kind of graduated into adulthood. And a lot of our webinars were born out of my own frustration of why is everything that we do as parents with kids with disabilities so hard? Everything we do, whatever the topic it is that we're talking about, is something that's difficult and challenging, and it's hard to know exactly what is right and wrong because there's a lot of misinformation that floats around. So our YouTube channel was born, the Consolidated Planning Group YouTube channel you can subscribe to for free. All of our past webinars live on that YouTube channel, so you can kind of look at the topics for the step that you are on in your journey and get valuable information there. It's my goal to equip you with tools and resources that you can use for free that will help you advocate and build a plan and really have a good path forward as it relates to planning for your loved one with a disability. We help people put protection plans in place. We build lifetime care plans. We do a lot of transition planning. We help set up ABLE accounts, and we do a lot of advocacy by way of webinar. And one of the things, if you've attended in the past, you've heard me say, and I will say it over and over again, when it comes to planning for a loved one with a disability, your scenario, your life is specialized. It's not the run-of-the-mill average legal documents, average financial steps and things like that that an average family takes that has children that are neurotypical. It is important, just as we, from a medical perspective, if you have something wrong with your heart, you're not going to go to the PCP, the primary care physician. You're going to go see a cardiologist. You're going to go see a heart doctor, somebody who is specialized in that. And we recommend that as well as it relates to both your legal your legal documents as well as the financial steps that you take. Not all attorneys are nuanced in planning for special needs. They're not all nuanced on all the hoops and loops that we have to jump through as families to preserve eligibility for state and federally funded programs. And that is true as far as financial advisors are concerned as well. There are many financial advisors all across the United States, but fewer than 1/10 of 1% of all financial advisors have any background in special needs. And it's so critically important because you could accidentally mess up eligibility for state and federally funded programs such as Medicaid waivers, SSI. Those are some of the programs that can accidentally get messed up. So we really encourage, whether you work with us or you work with Hayes and Wilson or someone else, we really encourage you to work with somebody who is specialized and specifically nuanced with special needs. We think it's very important. So having said that, Cynthia, I'd like to invite you to talk to us a little bit about the Turtle Wing Foundation, and then we're going to dive right into our topic today with Julia.
Thank you so much. My name is Cynthia Fogelman. I'm actually the Family Engagement Coordinator for Turtle Wing Foundation. Turtle Wing Foundation is located in Schulenburg, Texas, so Central Texas. We serve currently 3 counties around us, Fayette County, Lavaca County, Colorado County, but we are growing and pushing out those boundaries. And what we do is we help all children in our rural communities that have different special needs. They're maybe on the autism spectrum, and we help connect their families with the service providers locally. So they're not having to go, drive to the bigger cities to receive ABA therapy or speech therapy, OT, even academic services. So we like to say that we're a service hub. So we connect them, but we also do help pay for those services as well. So if a family their insurance doesn't pay out of pocket for that, we will help cover some of the cost involved in that. We began back in 2011 already, so we're entering our 14th year, I believe. And the foundation was created in memory of Jackson Allen Hooper. He was 9 years old when he passed away, and he was high functioning autistic. And his mother, Deanne, after he passed, wanted very much to help the children in our area who were like Jack. She had to go to all those big cities way back when just to try to find services. So her heart is to help those families in our rural community connect with services. So we really do appreciate the partnership with you to help our families plan for the future. Thank you so much.
Thank you for doing what you do. And it is true that sometimes when you're living in smaller cities and counties and things like that, you don't have the same services or access to the same services that some of the bigger cities afford. So I'm really glad that you're doing what you're doing. It's really, really important and we need you. So thank you. Thank you for what you're doing. So guys, if you're in those counties, reach out. If you're not in those counties and you want to learn more, definitely reach out and they may be able to connect you because as she said that they are definitely growing. So we're excited about that growth for you guys as well. Well, Julia, it is a pleasure for you to be back with us. We have been partnering with Hazen Wilson for years on these webinars. Hazen Wilson is a trusted source that we have sent referrals to. So one thing I always like to make clear is what we do and what they do. A lot of people call us all the time and say, I need guardianship or I need a special needs trust or something like that. And we refer out for those. So they're the paper, they're the legal documents, you got to have them. And we're the money. And they don't do what we do and we don't do what they do, but we work closely together. And so sometimes there's confusion if you haven't started this process before of why do I need both or who does what. So I just wanted to clarify that. But Julia, I'm certainly glad that you are back with us. Tell us a little bit more about yourself and let's dive right in to today's topic.
Sure. Thank you so much for having me, Allison. And Allison mentioned that questions are welcome in the chat. Please feel free to jump in the middle of the presentation. You don't have to wait until the end because there may be things that you find interesting, want to know more about. There's a lot of these topics that are, I would say we could do an hour presentation about each one. So for a little background, as Allison mentioned, I'm an attorney. I work in special needs planning. So about a third of our practice is basic estate planning. So wills, power of attorney, trusts, any kind of planning on the front end before someone passes. And that's for families with special needs children. That's for your mom and pop. It's for multi-million-dollar estates. So we don't, discriminate on that front. We'll help anyone with their planning needs. And then another third of our practice is probate on the back end. So after someone has passed, how do we take care of their estate and manage their assets? And then the final third is exactly what Allison alluded to. It's special needs planning, it's guardianship. We're very focused on that field. So it's a big part of what we do and something that we feel very strongly and passionately about taking care of these families. So jumping right in, as I said, there are a lot of these topics that I could talk about each one for an hour. So this is going to be a high level overview of why we need to plan for incapacity. And here, when I say incapacity, I'm not talking about our children. So I'm actually talking about you and me. What happens when, the person who is previously able to take care of things is no longer able to take care of things. And so we say incapacity, sometimes it's just unavailability. Maybe you've taken a 6-week cruise in the Mediterranean, and do you have anyone empowered to call your insurance company or deal with your utilities or pay bills while you're out of town? Sometimes it's a true incapacity. So it could be a traumatic brain injury, Alzheimer's, illness. It could be a physical incapacity. My brother broke his femur a couple of summers ago, and while cognitively he was fine, he could not move around. He was in the hospital for 17 days. So at that point, he needed someone else to step in and take care of things for him. So when we think about estate planning, pretty much everybody has an idea of a will or a trust. They know estate planning means who gets what when I die, and maybe even the secondary part of who takes care of what when I die. And that's great, but what you really care about is what happens while you're still alive. So while you're awake to watch it, while it affects you. And so that's when we come in with the incapacity planning. So there's two sides to this. One is the financial. So that's, as I said, paying bills, dealing with your digital assets, calling insurance companies, anything that has to do with your income and assets. And then there's the medical side. So who can make the decision? Do we do the surgery? Do we take you off life support? Should you be placed in rehab hospital? What kind of options are available to you for long-term care? That would be the medical side. So that brings us to the financial side. So there's several mechanisms for managing your income and assets while you are still alive. So again, you haven't passed, but for whatever reason, you're not available, you're not capable of managing these things. And so there's a brief list here. There's actually a few more options than this, but this would be the list that I see most common, that they're most easy to implement. So things like joint accounts, having somebody appointed as an agent under a statutory durable power of attorney, also sometimes known as the financial power of attorney, general power of attorney. Those have somewhat different meanings in the legal field, but broad strokes, they're all the same thing. It's someone else who can step in. It doesn't take any power away from you, but someone else who can step in and act on your behalf as far as your income and assets. There's revocable living trusts. So a lot of financial planners and estate planners recommend the living trusts. I'll go into that. There's some pros and cons to it, but if your assets are in a trust and you have a co-trustee and something happens to you, then there's already someone else empowered who can step in to manage those things. Supplemental care trust is another name for a special needs trust. In this case, we're thinking of a third-party special needs trust. So I'll get into that as well. Payee representative, representative payee, depends on what program you're in, but that's another way for someone to receive government benefits on behalf of the beneficiary. And then if it comes down to none of these previous solutions have worked, our final solution is guardianship. And so that would be a court appointee who steps in and has control over all of the assets.
Julia, I wanted to talk about that representative payee just for a moment, because a lot of
Sure.
families they have a child that is either getting SSI or childhood disability benefits, formerly called DAC. Sometimes they call it SSDI. We have a lot of interchangeable names that people use. But this is when your child does not have capacity and you are the representative payee, so they pay the benefits to you on their behalf. One of the things I have an issue with this, and I just want to make it clear to everybody out here. The Social Security Administration doesn't tell you that you can name successor representative payees, but you absolutely can. It's free. You should. You can name up to 3 successor representative payees on your person's account. Now, that person is still going to have to be vetted, meaning like if you die, that person is still going to have to be vetted. They can't be a criminal. They'll take you through the same vetting. They'll take them through the same vetting process that you went through to become a representative payee, but it will expedite the process much, much quicker. And we've seen people that have passed away where the parent has passed away. They were the representative payee, and there was not a successor representative payee where it took like 2 years to get it worked out. They froze the benefits. They ended up paying them back, but it's it's a mess. So you can
Yeah,
prevent
that lump sum back payment can be a huge problem too.
Exactly. So you can prevent this, and you can go to the Social Security website and look at this on how to name a successor rep payee, but you can absolutely do that, and you should. So please do check into that. One person said, "Will I need a special needs trust if I opt to get guardianship for my 16-year-old child eventually when they turn 18?"
Yes, no. So that's a complicated question. When I get into special needs trust and guardianship, I'll go into that a little bit more. So those are probably two different functions, would be my guess. So there are guardians of the estate, but if you're talking about a child who doesn't have their own assets, then you will probably want a special needs trust in addition to the guardianship. And so I will dive into, I know I said ask your questions right away. Actually, I do have some slides on that. So I'll get there and dive into that a little bit further once I get to that
And
point.
because we have people that attend from all across the United States, not just in Texas, this is specific to the Texas laws as far as special needs trust and guardianship is concerned. Different states do things differently, and some states do automatically do guardianship of the estate and guardianship of the person at the same time, and that's not really how it works here. So I just want to let you know that. And then some states call it conservatorship. There's different options, and like I said, it's very specific to the state that you're in. We have referrals for attorneys in your state, so you can reach out to us if you are from another state and need additional information.
Awesome. All right, so thank you so much for that. So just looking back at what I was going over with different ways to have someone else manage your assets and income. Joint accounts is a very easy way. You add somebody on your account who has access to that account. They can write checks on that account. They can pay bills at that account. It's adding somebody to that account does not make it a gift. So just because you've added somebody who can write checks on your account does not mean that they now have ownership of those assets. In fact, the ownership is still based on who deposited the funds, which admittedly can get tricky if you've got two people depositing funds, say daughter and dad, and then one of them passes. So, typically what we would do is we would say this is all dad's account, but daughter has the ability to write checks and pay bills as needed. And then there is also a concept of convenience signers. So a convenience signer doesn't have any ownership interest in that account. They are just someone who can sign off on it. So there's no question of when the second one dies, who it belongs to. And so the convenience signer can be, you just add them as a signer. Each person has to sign the signature cards at the bank. It functions very similarly to a joint account, but it could also be a convenience signer under a POA. So if you have that financial or statutory durable power of attorney, they could be added to the account as a POA or a convenience signer. I will tell you from experience that the banks are far more likely to accept that if the principal, so if it's my account, if I add that person or I give them my power of attorney. If my agent shows up with the power of attorney, then they're going to have to jump through a few more hoops because the bank obviously wants to make sure that those funds are protected, that someone's not coming in maliciously. But the great thing about this is that if somebody's added now while you have capacity, you're awake to watch them. So if they do something you don't like, you can remove them. And so my theory on that is that if you can't trust someone when you're awake to watch them, then you certainly shouldn't trust them when you're incapacitated. So don't add someone if you think that they're going to do something that you wouldn't appreciate. And then one thing that you do need to look out for is that adding someone as convenience signer, adding someone as a joint owner on the account does not necessarily mean that they have right of survivorship. So sometimes you want a right of survivorship. You've got one child, they're going to inherit everything from you anyways. You want them to be able to access your account after you pass. So you want that account to be styled joint tenants with right of survivorship. But for many people, they say, well, my daughter's taking care of this, but I have 3 children. When I die, I want it to be divided between all 3 of my children. And so I don't want a survivorship provision added. I want it to just be tenants in common. When I pass, it goes back to my probate estate and we can divide it up accordingly. So look out for the well-meaning banker. We've seen this a lot where they add a right of survivorship or a pay on death, which is just like a beneficiary designation for cash. Transfer on death, same thing for stocks, bonds, securities. We don't necessarily want that when we set up the account as joint. So then that brings us into power of attorney. So a power of attorney is like being a convenience signer, except that it's much more broad. So as I said before, appointing someone as an agent under a power of attorney does not take any power away from you. So you can still manage your own income and assets. You still have capacity. You can take care of everything on your own. But it does allow someone to act on your behalf. And so you can structure them such that this document is effective immediately upon signing. You could structure it where it only goes into effect upon your incapacity. I generally recommend the former. So as I said before, if you can't trust them when you can watch them, don't put them to come in when you're incapacitated. It just causes a lot of problems. And likewise, if you say that it only goes into effect upon your incapacity, then you're letting that third party define what incapacity is. So do you have to have two doctor's letters? Do you have to have, an actual guardianship, in which case the power of attorney becomes null and void? So I don't like to let third parties, so banks, financial institutions, insurance companies, utilities, whomever it might be, create the rules for my client. So I would rather that it goes into effect now and they can force that third party to take it. They can't always force them to take it, but there's a lot more teeth to the law if you have it effective now. And so a third party cannot just reject it nilly-willy. They can't say, it's not on the fidelity form. It's not been signed within the last 6 months. They used to reject powers of attorney for all kinds of reasons. Now, at least in Texas, as I said, the document has a little more teeth. So third-party institutions can't reject statutory powers of attorney without giving a reason. And so they can say, there's allegations of fraud, or we need a certification that this power of attorney hasn't been revoked, that it's still in effect. That's fine. I don't mind doing the extra legwork to prove up the power of attorney, but they can't just make up arbitrary rules on when they will or will not accept that document.
Julia, I just wanted to mention, because I've had a lot of experience this with big banks, not to be named, but you can imagine the three big banks. And it is difficult at best. The person that you're sitting in front of them is usually not knowledgeable about this. They have a legal department that they have to call. It's not a fast process. There's typically misinformation. I've had to get my attorney on the phone because of that kind of thing. So just be patient. My point is, put your patient hat on when you're going into the bank with this kind of thing. It's not always perfect. It's usually bumpy at best, has been my experience. And that's with the big banks, and I can't imagine how bumpy it might be with the smaller regional banks. It's tough, and so I just want you to be patient when you're working through this.
So sometimes the community banks or credit unions are actually a little easier because they know the principle. So they're like, oh yeah, I mean, your Uncle Bob has talked about you all the time. Every time he walks in here, I know you're trustworthy. Whereas the big banks, they don't know you from Adam.
Sure.
But you're right. And so that's why I suggest that while you are still well, assuming that at some point we're all at risk of incapacity, you provide that document to your bank or your financial institution so that it's coming from you. It's not coming from your agent, it's coming from the principal. And if you could flip the slide one more. This is kind of a blanket list of the statutory powers given to the agent, meaning that under the Texas Estates Code, these are all of the things that an agent under a power of attorney can handle unless you have specifically opted out of those things. So it's what I talked about before. It's banking, it's dealing with benefits, it's dealing with Social Security, Medicare, Medicaid, the IRS, digital assets. That said, just because it's in the statute doesn't mean that every third party knows or understands the rules. So Allison's exactly right that sometimes you're having to explain it to them. And I will tell you that the government in particular, so Social Security, Medicaid, Medicare, they do not always care what your power of attorney says, and they would much rather talk to the representative payee than the agent under a power of attorney. So keep
And
that in
in
mind.
fact, they won't.
Yeah,
The Social Security Administration does not recognize power of attorney. It doesn't matter that you have a legitimate legal document. They recognize representative payee, they recognize guardianship, and there is a form, and I'll look it up and put it in the chat box that you can get. I'll have to look at, I'll give you the form number which you can download, and they will talk to you on behalf of the individual if you're not the if you are not the representative payee, but they absolutely do not recognize a power of attorney. It's as good as nothing with them.
right. And yeah, so when we represent people before Social Security or Medicare, Medicaid, we have got to have that form. So I know exactly what you're talking about. So that brings me to, I think it's 2 slides from here, the limitations on a power of attorney. So the power of attorney does have a lot of power. The agent can take care of many different things for the principal, but they can't take care of everything unless they've been given that specific power. So there, we can add hot powers to the document. So this is the statutory document. This is what's included under the Estates Code. But the Estates Code says that as long as it's in a substantially similar form, you can add language to it. So often we will add language that allows the agent to make gifts on behalf of the incapacitated person or just the principal. And that serves 2 purposes. One, if they already have a history of gifting to the kids, the grandkids, church, charity, we can continue to make those gifts that they already had a history of making. But more importantly, sometimes if we're looking at Medicaid qualification for this person who was previously had capacity, now is getting older, maybe doesn't have the same abilities that they had before, need Medicaid skilled nursing, we might look at whether there's any non-penalized transfers that we can make in the gifting world in order to allow that person to qualify for Medicaid. So we often use the gifting power under the agent's authority, but we have to write it in specifically. So the principal has to sign and give that power before they become incapacitated. Likewise, the agent under a power of attorney cannot change beneficiary designations, establish a trust, amend a trust, unless that's specifically detailed in the document. And so we like to add those in as what we call the hot powers. And even if the power of attorney specifically grants this power, we're not necessarily going to let them represent the client before the IRS. There is an IRS form, but IRS is very similar to Social Security in that they're very hesitant to accept the designation of an agent under a power of attorney. And the power of attorney may not be able to make Medicaid transfers if they are going to cause a penalty in time, and they may not be able to establish a trust. So it's very much going to be fact dependent on the language in the document. So the only reason to bring this up is that there are plenty of statutory durable power of attorney forms available online. They are the exact language that's in the statute. There's no reason why you can't use them. But if you're planning for incapacity, you might want to go to a drafting attorney that can add in these extra provisions that deal with unusual circumstances, less common circumstances. And then there are certain powers that cannot be delegated. So you can't stack fiduciary duties. If you're an agent for somebody who is also a trustee, you as the agent can't step in and become the trustee of the trust. The agent under a power of attorney cannot make a will for that person. They can't appoint a medical agent. They can't initiate a divorce or designate a guardian. So it's a limited document. It's a powerful, helpful document, but it doesn't do everything. It's not a silver bullet. Okay, so I talked a bit about those hot powers. We can go ahead and skip that. I've got a lot of information to cover, and I don't want to spend the whole time talking about powers of attorney. So, Allison, if you could get me over to the living trust slide. There we go. Perfect. So living trust is like a power of attorney, but with bonuses. So living trust is a way to style assets. So it's a relationship between the grantor, the person who initially owned the assets, the trustee, the one who manages the assets, and the beneficiary, the one who takes the benefit from the assets. So in a living trust, that person is all three. Usually. So I could create a trust that's established during my lifetime. I'm the trustee, I'm managing my own money, I'm the beneficiary. I can take the money out, I can pay my bills, I can do whatever I need to do with that trust. And so during my lifetime, it can be amended, it can be revoked. And so it offers me an option to do planning for what happens during my lifetime if I become incapacitated. It offers me the option to do some planning on what happens when I die. So at that point, the living trust serves like a will, and it designates who is the beneficiary of the trust, how my estate would be divided. And so typically what we do is you fund the trust now with your own assets. And then there may be things like an IRA, 401k, other retirement products where when you die, the beneficiary becomes the living trust. If you have an anticipation of incapacity, you will appoint a co-agent or successor agent. So this is great for if you've just been given a diagnosis of early onset Alzheimer's. And right now you can manage your own income and assets, but you look at this and you say, I understand that at some point in the future, I'm going to need some help. I'm not going to be able to make sure that everything's taken care of. And so having a co-trustee means that person's already empowered. They can already see what bills are being paid every month. They can help you set things up with auto pay. They have access to the funds. And unlike the agent under a power of attorney, if someone is co-trustee, that means they have equal power with you. So you don't have to worry about that third party stepping in and saying, you don't have the authority to pay these bills. You don't have the authority to access this.
And the access to the funds is going to be important in incapacity because care. I dealt with this for two family members, and their care bills were in excess of 8 grand a month, $8 to $10,000 a month, which they had money to pay, and it was set up properly so the bills could be paid out of their funds to pay for their care. But if it's not properly set up, they can have all the money in the world and there's no access to it, then there's real issues because your traditional health insurance, your traditional and Medicare, they don't pay for long-term care. You've got 100 days of skilled nursing with Medicare. So this is really a big deal, and people don't even really know it's a big deal until it happens and it's wrong, right? And they find out the hard way that it's not set up properly.
Yeah, and that's a good point about the skilled nursing. So Medicare pays for the first 20 days, and then they'll pay the difference between the average cost of a nursing home and whatever you're actually paying for your medical rehab for days 21 to 100. So that means that the first $164 a day, something like that, the client is responsible for, which, as you said, they can have all the money in the world. If they can't access it, it makes it really difficult.
Doesn't matter. Yeah, it's a big deal. And a lot of people have a misconception of what Medicare will pay for. I mean, truly long-term care coverage is what covers long-term care facilities, and if absent that, we've seen things covered by the VA for a veteran and things like that, but there's not much coverage out there unless you have a long-term care plan. A person asked, if I obtain guardianship, will my income affect the amount of SSI benefits my loved one receives, or is it still based off of the disabled individual's income and assets? It's going to be the disabled individual and asset. It doesn't matter if you claim them on your tax return. It doesn't matter if they live in your house, and it doesn't matter if they're under full guardianship. Once they turn 18, it's based off of the individual's income and assets, not yours. Prior to turning age 18, many kids don't qualify for SSI because prior to turning 18, it's based off of the parent's income and assets, not the child's. So that's a great question.
Yeah, You can be a billionaire guardian and it's still going to be the same amount for the disabled person's SSI. So, alrighty. So I had gone over some of the advantages of the revocable trust. So we use them specifically for incapacity planning. And then also if you own real property in several states. So if done correctly, and I'm going to come back to that phrase, if done correctly and fully funded, then your living trust will avoid the need to go through probate. In Texas, probate is a fairly straightforward and simple process when you die, but in many other states, it's not. And so we don't want to have to probate in Oklahoma and California and Texas. So if you've got real property in multiple states, each state has their own jurisdiction over the real property located in that state. You might want to put it into a living trust. And so likewise, if you move frequently, you don't want to have to update your estate plan every time you move. If you're a military family, things like that, living trust can be super helpful. Avoiding probate also adds a little bit of privacy. So I know that there's some concerns there of an inventory that has to be filed at the end of the probate process. There's other ways to avoid that. So there's an affidavit in lieu of inventory, but the disposition of the estate is kept private. So you see that it goes to a living trust, but you don't know the terms. Your average human cannot just go look up that you're giving 10% to child A, 90% to the special needs trust for child B.
I just wanted to chime in here, Julia, to make it clear that right now you're talking about a living trust. You're not talking about these standalone special needs trust. And you talked about funding now versus funding later and things like that. One person said, "What's the best program to keep money if I need access to it regularly for basic needs for my disabled child? Is that a trust or a Texas Able account?" Do you have any thoughts on that?
Yeah, so yeah, you're exactly right that the living trust would be your own assets. That's your own income and whatever else you own. It's not what you're setting aside for the benefit of your special needs child. For the special needs child, I love ABLE accounts. You can only fund them with a small amount per year. So it's 18,000 this year, I believe, or 19,000, whatever
Yeah.
the gift exemption amount
And
is
an additional, it's 19,000, and if the child is working, they
as
can
an
put up to
income.
their earnings amount up to a cap of 15,560 additional.
Right. So ABLE accounts are super useful, but if you're putting in 19,000 plus 15,000, you're going to be getting up to that 100,000 fairly quickly. And so ABLE accounts do not count against them for purposes of eligibility for Medicaid or SSI up to 100,000. And so they're a great way to put money away and save it for them and allow it to grow tax-free, but it's limited. You can't put, millions of dollars in there for their benefit, and you can't overfund them in the course of 1 year. And the other negative, I don't know that this is a negative. I actually think this might be a positive to enable account, but it has a Medicaid payback provision. So if there's anything remaining in the ABLE account when the beneficiary dies, then that goes back to the state. So it reimburses Medicaid, which the positive side of that is that it keeps the program going for the next child that needs it, which obviously there's always going to be special needs children or adults who need this program. But on the other hand, if it's your money that you've worked for and you're making a gift to your child's ABLE account, you might want it to go back to your other children when that one with special needs passes. And this would cause the state to be reimbursed first. So,
I
as
just
far
want to say here too that, we have some families that, don't like that because of the Medicaid payback. And then other families say, who cares? The max you can have in there is 100,000. Medicaid will have far more paid more than they will ever get back. Some
that's
people
true.
use an ABLE account as a savings to spend account, so the balance is never near 100,000. And so that's how I do it with my special needs kids. But the other thing, the point that I want to make, because some people say, well, should I have an ABLE account or should I have a special needs trust? My answer is
Both.
you should have both. Yes.
Yeah.
And the last thing that you got to know is you cannot make a beneficiary an ABLE account. So you can make a special needs trust a beneficiary for the benefit of said child, but you can't like leave your 401k to an ABLE account. It's not it's not possible. You can't do that. So, and an ABLE account can pay for shelter, without a 1/3 reduction to SSI. And as it stands right now, if you pay for shelter out of a special needs trust, there would be a 1/3 reduction to SSI. So what you got to know, we have entire webinars, the whole webinars on special needs trust. We have entire webinars on ABLE accounts and what you can and cannot pay for out of set of accounts. But those are great questions.
Yeah, and I saw the comment pop up in the chat. That was a follow-up that a trust seems like it's more difficult to access the assets. And I'll tell you that's not the case. So a trustee can own anything that you and I can own. So in a trust, you could have a savings account, a checking account, an investment account, real property, shares of an LLC. So there may be assets in the trust that are not liquid, but you can have a checking account, you can have a debit card that's all contained within the trust, and you can easily access it. So that's something that I would be happy to dive into further on a different day. As Allison said, we've got a lot to cover today, and some of these topics are really, we could talk about them for hours. And so I'm really trying to not be in the weeds here. Going to give you the high level, but a trust in general is not difficult to access unless you have, a corporate trustee or someone else. But if you're serving as your child's own trustee, you've got access to it. Alrighty, so we talked about the positives of a living trust. What about the negatives? So I get calls all the time from people who say, I listen to Susie Orwell, I listen to a podcast, I need a living trust, I have to have one. If I don't have one, then my estate's going to go through probate and I'm going to lose it all to the state. That is not correct in the slightest. So as I said, probate in Texas is not a particularly burdensome process. We don't have anything that just automatically escheats to the state. We have what's called a laughing heirs statute, meaning they're laughing all the way to the bank. So if you don't have children or a spouse, they're going to go back up to parents, grandparents, aunts, uncles, second cousins, once removed, however far we need to go to find you an heir. And living trusts also don't give you any creditor protection. So as far as the state of Texas is concerned, it was your money, you're taking the benefit of it, you have control over it, it's all still you. So if you get sued and you have money in a living trust, they can still come after that money. It doesn't give you any estate tax advantage. IRS looks at that and again says, that's all still you, we're going to tax you on it. It doesn't give you any income tax advantage. It doesn't have its own tax ID number. It's all under your Social Security number. So you don't get any of those advantages from having a living trust. And then the biggest disadvantage that, well, maybe not the biggest disadvantage, but one of the huge disadvantages is this perception that if I have a living trust, I automatically avoid probate. And that's not the case. So oftentimes people have an asset, so checking account, savings account, that was never funded into the trust, or a car or a refund. So mom lives at Eagles Trace, paid in to have her apartment there. When she passes, she gets that retainer back. And so there's a $200,000 check coming to the estate that isn't in the living trust, and we've got a probate to go get that. So sometimes we do all the work to fund a trust on the front end and still have to go through the probate process on the back end. And then I didn't put this on the slide, but it occurs to me that we're doing incapacity planning and Medicaid planning. So one of the biggest pitfalls of the living trust is that assets in the living trust are countable for the purposes of Medicaid eligibility. So if I need to go into Medicaid skilled nursing and I own my home, it is not countable up to a certain amount of equity. And it doesn't count against me for purposes of qualifying for Medicaid skilled nursing. If my house is in a living trust, it is suddenly countable. So sometimes people do all this work to fund the living trust, and then they become incapacitated, need skilled nursing care, and their agent under a power of attorney has to come in and undo the trust, get it all out of the trust so that it's not countable for the purposes of Medicaid eligibility. So that can be a major disadvantage to the living trust. All right, so then Allison was nice enough to move us over to the supplemental care trust slide. This is something that I'm sure that you guys will have a lot of questions about. We've already seen some questions about it. I'm, again, going to try to give you this high level thinking about it, and then we can dive in deeper if we've got time. So supplemental care trust is another name for a special needs trust. So The generic term is special needs trust. Supplemental care trust usually refers to a third-party trust. So this is a trust that is not for my own benefit. This is a trust that I'm creating for the benefit of someone else. So special needs trust is designed to maintain someone's eligibility for government benefits. So yes, we want someone else to manage the money for them because they may not be capable of it, but also we want them to not be disqualified from whatever government benefits they would otherwise be qualified to receive because of these assets. So first party is going to be the beneficiary's own assets. So if I am in a car wreck, I end up disabled from that wreck, there's a lawsuit, the proceeds come to me, they will put them in a first party special needs trust so that I can still get, Medicaid, Medicare, whatever help I need, and also have these assets available to me for my future care. Sometimes we have grandma who leaves, our special needs kid $5,000 because she really cares about them and she wants to make a nice gift to them, except that now that $5,000 has just knocked my kid off of SSI and Medicaid, and that's not particularly helpful to me. So we can take those assets and fund them into a first party special needs trust. Just like the ABLE account, this has a government payback provision. So if there's anything left in the trust when that person dies, then the state is reimbursed for their services. And we can only create these for persons who are under age 65. So if, it's time to go into the nursing home and I'm over age 65, that special needs trust isn't going to be an option for me. It's not available because they don't want everybody to just move everything over into a first party special needs trust in order to qualify for Medicaid. There are some Medicaid qualification trusts, but this isn't one of them. A third-party special needs trust is what we think of for our children. So when I die and I want to leave something to a special needs child, I can establish this trust for them. It can be through my will, it could be a standalone trust, but this is setting someone else up to manage the money for my child. So it could be a corporate trustee, it could be an individual, but it does not have to have a Medicaid payback provision. So the beneficiary never had a right to demand that distribution. It wasn't theirs to begin with. It was mine, or it was grandma's, it was someone else's. So that beneficiary didn't have a right to say, okay, that's my money. And so Medicaid doesn't look at that, or SSI, Social Security, any of the programs that are means-based tested don't look at that as the beneficiary's money. And so it keeps it out of their estate as a countable resource. All right, so we talked about this already, the representative payee. One thing I did want to note is that second bullet point. So just because you're someone's agent under a power of attorney, just because you're appointed as someone's guardian, does not mean that you are necessarily going to become the representative payee. You have to fill out the paperwork. Each agency has their own process. So if you want to be a representative payee for Social Security, that is going to be a different paperwork if they go from receiving SSI to RSDI. You've got to reapply to be the representative payee. It's government efficiency, so just take it with a grain of salt. Bring your most patient hat to anything that you're doing that deals with Social Security or Medicaid.
We did have a quick question today
Sure.
that said, how likely are the benefits such as Medicaid and SSI going to be affected by the current administration? I know that there's a lot of people that are fearful right now of things going on and things are up in the air. There may be changes. We're, as a firm and fully nuanced and special needs, we are not overly freaked out on what's happening. Everything changes from time to time, but we don't think that people are going to unilaterally lose their benefits or unilaterally lose. Well, we've had issues in the state of Texas with Medicaid. That's a whole nother story, a whole nother webinar. But we don't think that they're just going to go away. So if you have fears of that, I don't think that I don't think that that's something that you have to worry about. Like one thing I saw last week, for instance, I saw that they changed the payback. So if you owe the Social Security Administration, they've overpaid you and you owe them, they've been taking that overpayment back at 10% each check. And that new amount is going to 100%. And so people that are on here might think, oh my goodness, and that means that I'm not going to get a check going forward. Well, that would be true, except for the people that are already under the 10% payment plan. It's going to stay there. It's new overpayments that they're going to start collecting at 100% at a clip. So there, keep your ear to the ground, stay with us. We will have updates as it relates to the Social Security Administration, but don't worry. I'm a fan of, we have a lot to worry about, especially as parents, and I'm a fan of not worrying about the things that we absolutely can't control. Keep our ear to the ground, and we will adjust and adapt accordingly, and put out any new information out there. But that is a good question, and a lot of people are feeling the same way right now.
Yeah, the one thing that I think that I've seen is going to be a concern, again, don't borrow trouble. I agree with that completely, is the timeline. So things are already fairly slow as far as Social Security processing goes. And if there are fewer employees who are working for HHS, which is through the state of Texas, but receives federal funding, if there are fewer employees who are working for Social Security, things are going to take longer. So if for some reason there is a disruption in service and you're having to go through the appellate process, it might take longer to get an answer. That doesn't mean that it's going to be taken away from you. It means that you've got to be patient.
There also was something great that happened for any teachers that are on here, or government workers, or things like that. The Social Security Administration earlier this year, I think it was January, they got rid of the windfall elimination and GPO, the government pension offset. So if you're retired or already retired, if you're a retired teacher, you may have not been able to draw off of a spouse's record or other things like that because of WEP or GPO. It may warrant a trip to the Social Security Administration or to file for benefits. You may be eligible for benefits that you were never eligible for before. Like, I know my mother was a retired teacher, and her spouse was worked in the public sector, and as a result of that new change, it's several $1,000s a month. She went from none to several thousand, so it could be beneficial to check it out. You may not hit the criteria, but it's definitely worth it to check, even if you've checked before, because the law changed January 1st.
Yeah, that's great information. Thank you. So we're running a little short on time because I took way too much time to talk about the asset side of this. So let me run through the medical side of this. So the default is self-determination. So that means that each of us have the right to make our own medical decisions as long as we are capable of doing so. And that includes declining to receive medical treatment. So if you have a terminal illness and you get to the point where you elect to go on hospice and just ease your transition and die as gently as possible, you have a right to do that. And so that's the default. That's what we're working from, is self-determination. But there may be a point when you do lose some of that autonomy and someone else needs to step in. So there is a statutory default. That's what we see, the statutory surrogates. That is the person who can consent to medical treatment for you in the event of an emergency when you cannot understand what the options are, when you cannot advocate for yourself, when you're unconscious and can neither advocate for yourself nor have a conversation about what the risks and benefits are. And so if you're in a hospital or a nursing home, otherwise physically or mentally incapable of making your medical decisions, the default is your spouse first, an adult child who has the waiver and consent of all other adult children to act as the sole decision maker. So that can be pretty difficult to get. That requires all the siblings to sign off on it. A majority of the patient's reasonably available to adult children, which it doesn't say adult children who are also themselves capacitated. So if you have a special needs child, that could be a problem because they're asking them as well of what they think. Then your patient's parents, and then somebody who you've designated to act for you before you become incapacitated, your nearest living relative, or a member of the clergy, which, that's a pretty broad stroke right there.
Are you speaking of the Texas Family Code in the event that there is not a power of attorney in place?
Yeah, so I think it's actually the health and safety code, but yes.
Thank you.
Yeah, no problem. And so there's default, but you can do better. Like everything, you can plan out for yourself better than the state of Texas can do. Because as I alluded to, all of these things where you've got all the children coming together or appointing one of the siblings to be the sole decision maker, that doesn't happen in the real life. In real world, people don't always get along. They don't always agree what's best for mom. So I would recommend that anyone, regardless of age, so you turn 18, go ahead and execute a medical power of attorney. It's organic, it can grow, it can change with you. So, when you're 18, you appoint your parents. When you're 30, you appoint your spouse. When you're 75, you appoint your child. That's great. You can change it. You can update it during your lifetime, but at least have somebody in place who can act for you, who you think has the emotional capability to follow your wishes. So if your wishes are, I always want to be on life support, don't ever take me off, I want to keep fighting, then your agent under power of attorney needs to be able to do that. If your wishes are at some point enough is enough and allow me to die, you want to appoint somebody who's going to follow your wishes on that. And so you can customize your directive. There is a statutory form. This is also known as a living will, where you say, in the event that I'm either terminal or suffering from an irreversible condition, such as I'm in a vegetative state, here's what I want, whether I want with you to withhold life-sustaining treatment, whether I want you to continue life-sustaining treatment. A lot of people look at this and they think it's a DNR, so they don't want to sign it because they say, if I'm in the hospital and I'm receiving surgery and I code on the table, I want to be resuscitated. Directive to physicians and family has nothing to do with emergency resuscitation. This is your long-term care scenario. So you're in a situation where without this artificial intervention, whatever it might be, feeding tube, ventilator, artificial cardiac support, dialysis, you would be likely to pass away. And you're telling your family, your physicians, what you want. You can do much more specific documents. So we often work with the patients at the ALS clinic, and they might make a determination of, yes, I want to go on a ventilator until I become dependent on it. And then at some point, I want to be able to go off the ventilator. And that's all part of the bodily autonomy. But if you have those directives, it helps take the emotional burden off of your family members. And it also makes sure that your wishes are followed. There is still the human element of it. So when you appoint somebody as an agent under a power of attorney for the medical power of attorney, they have the final say if you don't have capacity. So they make the decision of whether we do the surgery, whether we take you off life support. Do we want to give you an MRI, see if there's a glimmer before we take you off life support? And so it can be very helpful to have that human element of somebody who can talk to your doctors, find out what the options are, and then make a decision for you. They're difficult conversations to have, especially if it's with your own children on what you want, but it makes a huge difference later on if you end up in that situation where you can't. I think I'm running pretty tight on time. So Allison had just put up my key recommendations, and we're going to send you this. So there were a lot of slides that got skipped about the guardianship process. I'm happy to answer those questions separately, or I think
I
one of
think
my
what we're
business.
going to do is we're just going to have you back, and the entire hour we're going to spend on guardianship, alternatives to guardianship, and what people need to know to get prepared. There was a question in the chat box that was basically asking, if my kid is 16, do I need guardianship? And as a parent, you are the guardian of your child until they turn 18, and it doesn't matter if they're disabled or not. Once they turn 18, then there needs to be some steps taken, and you can start that process with a law firm 6 months prior to the child turning 18, so that way it could be in place pretty close to age 18. But one thing that I see a lot, Julia, is that people are nervous about this. They're scared about it. Maybe their kids have some behaviors and they think that if they're guardian and the kid does something that they're going to be liable. And what I like to tell people, you don't have to go sit down with a law firm about guardianship and know everything there is to know. In Texas, it's least restrictive, most appropriate, and the attorney that you're working with is going to walk through that with you. They're going to talk to your child and they're going to go over what your options are, what are the lesser restrictive options, and help guide you towards what might be the best. So you don't have to know everything. I just like to tell people, take a deep breath. It's okay, because part of the process is set up to go through that and navigate that with you to come up with what the right answer is. You don't have to just call and say, I need full guardianship. It doesn't, and even if you did, it doesn't always work like that, right? They have to determine that it's the least restrictive and most appropriate for that individual. So I think that's what we're going to do. I'm going to have Meredith reach out to you, Julia, and let's get you back on the calendar and let's do a full guardianship one with your firm. Guys, Julia is available to set up consultations. So if you want to take a deeper dive with her on your legal documents, maybe that's the living trust, maybe that's a will, power of attorney, healthcare power of attorney, whatever those questions are. What I would like to say is, of the people on here, I would tell you that 90 to 95% of the people on this meeting today either have no documents or they have documents that might be considered largely outdated. We do recommend that people have their documents looked at every 3 to 5 years if you have a special needs kid. It doesn't mean that you're going to redo everything. It just means sometimes the law changes and it's good to have a second set of eyes. Maybe you had things done and you want it look, and maybe it was done by an attorney that's not really nuanced in special needs, and you want to have an attorney that's nuanced in special needs kind of take a look at everything. Those are all good activities to do. Don't beat yourself up about what you haven't done, but you're here today. So if you don't have your legal documents in place, let's put that on your list of things to get going on. It is really important, and we encourage people not to wait until the crisis happens, until somebody has become incapacitated, had a heart attack or a stroke or things like that. And while you're doing this for yourself and your own family and your special needs child, have intentional conversations with your family members, aging parents, any aunts and uncles, grandparents, anybody that you care about. Have those intentional conversations about their documents as well. So we're out of time for today. Everybody is going to get a copy of today's slides and a link to the recording. We're going to have Julia back. I know that we have Bill Hayes scheduled as well from Hayes and Wilson. And so you always provide a wealth of information, Julia. Thank you for that. And thank you everyone for being here today. Again, check out the Turtle Wing Foundation. Thank you, Cynthia, for being here. And we'll look forward to connecting with everybody again soon. Thanks so much, everyone. Bye now.
Thank you so much for coming.
Bye now.